we'll go ahead and take announcements.
Todd Alvey on behalf of the Texas Department of Family and Protective Services. I'm present, ready to proceed, Your Honor. And if after announcements, if you would allow me to have a breakout room with the attorneys so I can figure out where exactly we are on this case.
Okay.
Alpha for the mother, Erica Toro, we are both present, ready.
Okay, Michelson for Mr. Ibanez, we're present and ready.
All right, is he there with you, Mr. Michelson?
No, ma'am. I presumed he was with Miss Naranjo. Maybe I'm mistaken.
Is he present with you and your client?
No, Your Honor, he is not.
Okay, so I don't think
Then
he's
he would
present.
not be present. I've had some difficulty reaching him. The caseworker provided me with a number for him. However, I've not been able to contact him.
All right, thank you.
Stacy Zavala on behalf of the kids.
All right, let me set you all up in a breakout room. Ms. Naranjo, I guess your client will need to step out.
Since you've already called the case, Your Honor, at this time,
Ms. Naranjo and Mr. Michelson are still in their breakout room.
Oh, I apologize, Your Honor. I didn't realize.
No, they're still in there, so I don't know if they're still talking or if you need to go back in there with them or.
I can. Is Stacy still in there? No, but
No, she's.
I can go over there though.
all right.
Let me move y'all in there and or Stacy, you can put yourself back in there and I'll move Mr. Alvey.
Judge, at this time, the department is going to ask that you vacate our hearing today. We will be seeking a dismissal of this case. Miss Toro, we have some concerns with Miss Toro, but it seems like she's gotten the kids, two younger kids in school, older child maybe seeking her GED, which I'm good with. She seems to have, or at least on the face of it, being protected from Mr. Ibanez. We have concerns that he may still be in the Amarillo area, though I don't have any realistic or real evidence of that. We just have some concerns based upon things we've been told. But at this point in time, I don't think I have enough to proceed with this petition, and so we're going to ask that we vacate today's hearing.
Well, let me ask, I believe there was a no contact on a bond. Is that correct?
That is my understanding, Your Honor.
And that is correct, Your Honor.
Okay. All right. Well, that at least has a few teeth in it. So, okay. All right, then, Ms. Naranjo, is this what you all are wanting to do?
Yes, Your Honor.
And Mr. Michelson, same with you, I assume.
Yes, ma'am.
And Ms. Zavala, best interest of the children.
Yes, Your Honor. Based on the new information that the two younger ones are enrolled in school at this time, I do think it would be in the best interest to dismiss this case.
All right. Well, Ms. Toro, I'll go along with that. I just will caution you, that bond restriction kind of cuts both ways. If you violate that restriction, that restriction really loses its effectiveness. And, I hope that you will rely on that as, a tool that can keep you and the children safe at this time. So.
Yes, ma'am.
Okay. All right. Then when I'm presented with the order for dismissal, I'll sign it.
Thank you, Judge.
All right. Thank you all very much. Good luck, Ms. Toro.
Daniel Trout for the Texas Department of Family and Protective Services, and Christina Hunter is my permanency specialist. We are present, ready, Your Honor.
Judge Jeff Hill on behalf of Ms. Melton. I guess I'm ready to proceed without her. I just as Daniel was giving his announcements, I was looking at my phone at the missed call list. It does appear she tried to call me here just a few minutes ago. So as soon as I get done making my announcement, I'm going to mute you or mute myself and see if I can't call her and get her rounded up.
Sure.
Bill Taylor representing Ashton Lee, I believe he's presumed father. I've had no contact with him, no way of knowing how to get hold of him. Location unknown, Your Honor. But I'm present and ready.
Stacy Zavala on behalf of Emma and Harvey.
All right. So what do we have new from the department? since the court report was filed?
Basically, Your Honor, I've been able to obtain some more documentation from Northwest Hospital in regards to Sylvia. She did go in and out of the pavilion a couple times since our last hearing, trying to get clean and sober again. The last communication I had with her was on September the 11th. She had requested that her therapy visits be able to move to virtual because she stated she had restarted her job at the laundromat. So she lost it and then got it back. I still have not been able to verify that she has resumed employment there. However, she did state to me that she did get a house on the 4th of this month, but it is not currently livable. And so she's working on currently fixing that up, and she is supposedly residing with her employers. Again, I have not been able to confirm that either. I did speak with her therapist, and it is not therapeutically recommended that her therapy visits to be moved to a virtual. In the last hearing, I'm sure you remember, Your Honor, that her bosses did say that they were in full support of her to be able to work her services and do what was necessary. And I did remind Sylvia of that. And we also at St. Francis did not feel that it was in her best interest to have virtual visits, virtual therapy visits as well. So at this point, she's not engaged any further in any of the services. She's not had another therapy visit scheduled as of last week. The OSAR evaluation and the Padre referrals, I did resubmit those right after the last hearing. She still never went through completed the OSAR assessment, which is what she needed in order to get into the intensive outpatient program as a recommendation from that. So she's still not engaged in that either. It's the same as what it was before, Your Honor, unfortunately. Usage is still continued. That's pretty much it, unfortunately.
All right, and no further contact with Mr. Lee, is that correct?
Yes, ma'am, that is correct. I've not had any communication with him of any sort. She had, I'm sure you saw in the court report, Your Honor, that, she was drug screening pretty regularly for us. Since you so graciously allowed us to be able to screen her weekly, we did send her pretty much basically weekly. And then the hair follicle that she did for us right after the last hearing did come back substantially higher than the one that she did for us in May.
Has she done her UAs for us?
She was doing them for me up until she went into not Synacor, my apologies, up until she went into to detox. That's kind of when communication started getting really spotty with her. And then I requested that she go as soon as she did get out. She did complete that one for me as well. The most recent UA that she did for me, give me a second, Your Honor. I'll pull it up for you.
And one was the test, I believe. And
Yes, sir.
results came back on 9/7, were filed on 9/8 with the court, Your Honor.
Yes, sir.
The last UA.
That was the most recent one that she's done for us. I have not sent her since 9/1.
Sorry, Christine.
You're good.
I just happened to be looking
Thanks
at
for
it.
the help, Daniel.
I just happened to be looking at it.
Do you have contact information for the employers, the folks that she was working for and living with? And
I don't have their direct contact information, no ma'am. How I've spoken to them before is I've gone up to the laundromat and whomever the employee is that's working there, I just asked to be able to speak to their boss, and then they call them and I talk to them that way.
okay.
Would somebody mind emailing me quickly that September 1st drug screen that you have mentioned? I was never served with that for whatever reason. Or could somebody tell me, was it positive, was it negative, what was it?
It was positive, yes.
Okay, and I apologize for interrupting.
No, it's no problem. And she's logging in again. Let me try to let her in.
And while Judge is doing that, Jeff, the methamphetamine was at 1990. The amphetamine was at 624 and marijuana was at 941 were the levels on that test.
Thank you.
Mhm.
Also, Judge, I do have her on speakerphone here, so she is able to listen.
Okay, and we just got to get her connected to audio. It looks like, but that may be why she can't.
Well,
Okay.
I called her after
Yeah.
I had spoken to you when there was previous troubles.
Okay, I think
Oh, there she is. Okay, yep.
she's
with-
connected now.
All right, I'm
Okay.
gonna hang up on her.
Okay, then, Mr. Hill, anything to report this morning?
Well, I'd like to get some statements from Ms. Melton if she can. Sylvia, are you there? Can you hear us?
Can you hear me?
Okay, there you go. Yes, ma'am. Okay, so Sylvia, things have not gone as you would have hoped they would have gone since since we recessed, or since our last hearing. What can you tell the courts? You've heard about the positive drug screen, and you didn't hear it all, but CPS or St. Francis was describing how you really had made very little progress in their opinion moving forward. Can you explain to the court what you've been doing here these last couple of months and what's gone on?
Whenever I miss.
Okay, Ms. Melton, you're gonna have to speak up or turn up your volume. They're very difficult to hear.
let's see. Is that better?
It's
Can you
somewhat
hear
better. The court reporter is struggling to hear you, so if you'll just
Okay,
please speak up.
I'll try to speak loudly. I'm not trying to yell at you. When I missed the first drug screen that I missed, I relapsed because you had said do not miss one. And when I missed that one, I relapsed, and I relapsed hard, and I tried to kill myself twice, and I went into the pavilion twice, and I gave up because I figured there was no hope, because you were very adamant about do not miss one. And I did. And then once I talked to Christina after I had been in the pavilion, and she told me, she's like, well, just keep going and see what the judge says. You can't just give up now. And I literally had gave up because I love my kids, and I know my mental state right now isn't the best for them, but I want to try. I want to try to be that mom that I was for them before, because I was a good mom before everything went to crap. And I love my kids so much that if having to give them up is what I have to do, then I will. But I'm
Well, Ms.
still willing to keep trying.
Ms. Melton, everybody present here today understands that relapse is part of the process, or it typically is.
We don't have time for failure anymore.
Well, you are running out of time. What I will tell you is if you will continue to drug screen on a very frequent basis for us, we're set for our final November 30th, but our dismissal date isn't until February. So the truth of the matter is you've still got time to turn this whole thing around, but that is going to require 100% sobriety. You know, because come February, I mean, that February 2nd is the dismissal date, and you know, there's very little, there's very little I can do at that point as far as any more time. I mean, it's a drop dead date, but we are set for November 30th, but I'm willing to see what happens between now and then. And on November 30th, if things have gone very, very well and you've made a lot of efforts and a lot of progress, then, I'm willing to push it back another 45 days, or thereabouts. But, I don't know what to tell you. If you're tempted to relapse, you just have to know at this stage, if you do, I mean, the odds are very high that you're going to lose your children.
Yes, ma'am.
Because I just can't keep them in the cycle of waiting and waiting and waiting for you to get things turned around. It's just not fair to them.
It's not fair to them.
And it is also my job to achieve permanency for children, and particularly, kids that are the ages of your children. I mean, they're not babies, but they're young. And it's just, I've got to start looking at what can we do to get these children in a permanent situation. So
Sure.
I'm being honest with you, and, if you don't maintain sobriety, the outcome's not going to be good.
Right. I understand that. And I really appreciate you giving me this opportunity, because y'all don't do this.
Okay. Would inpatient help you?
I don't know. I mean, yes, but I mean, I still have my job and I just got a home. I have rent to pay and stuff.
How are you
Yes.
addressing getting help right now? I mean, are you in a program?
Not the Padre program, no, not yet. And I was gonna go to Senecor, but they want me to pay because I have a job. And so, yes, inpatient would help.
Would your employers hold your job for you?
I believe so, yes,
Would you lose your housing?
possibly. Because inpatient would be 30 days. Are we talking like the DWC, like years program?
I mean, you're talking a minimum of probably 30 days. Ms. Hunter, you got any ideas?
In regards to inpatients, the only ones that are local is Senecor and then Serenity, which is over in Plainview. I have
Yeah.
spoken to Sylvia about that one. She said she didn't want to go out of town. She wanted to stay here local. In regards to maintaining her housing, if she does go inpatient, unfortunately, I don't have any ideas on that. If she were able to enter Senecor, there is a program through Haven House. If she was able to be accepted through that she could actually still maintain how, like, get a housing and everything set up with them. It would be like almost like an intensive outpatient kind of type situation. Once she completed that, they would help her to maintain her sobriety as best as possible. There's a lot of restricted guidelines and stuff like that that would be included in it, but they'll also help her get her back on her feet as long as she works the program and stays true to the rules.
And Ms. Melton, I mean, I'm familiar with their program. There are several. There's a program through the Downtown Women's Center. There's Haven's House. There's Martha's Home. There are several programs like that quite frankly, I think are more tailored to what you need than just even the 30-day inpatient. You know, these are longer term programs and they'll work with you, and even you can get to a point in these programs where even children can be placed with you.
Yes, ma'am. I went through DWC in 2017-18 with my kids. I've been through it before, and it's a good program.
Well, I encourage you to talk with your attorney about that and with Ms. Hunter. I think it's what you need to do, but that ultimately will be your decision.
Yes, ma'am.
The only other thing that comes to mind, Your Honor, that was going to be kind of a big, it's not kind of, it is a big concern, is making sure that Sylvia is surrounding herself with people that are going to continue to influence her in a positive manner, that are not going to lead her back into the drug world, and, you know, put herself in a situation that's not going to be helping her move forward in the life that she's trying to create for herself.
Which is another really good benefit of those long-term programs, because part of that is trying to help you develop a support system. That's a big part of those programs.
Yes, ma'am.
Okay, Mr. Taylor, anything to add today?
No, I'd just like to ask Ms. Melton one question. Ma'am, do you have any information at all on how to contact the father of the kids?
Oh, no, I don't.
Thank
I
you.
haven't talked to them in a year.
Nothing further, Your Honor.
Ms. Zavala?
Your Honor, both children are placed together. They're both doing well. We're getting some follow-up medical on Emma to really try to pin down that GI issue, but she's got a number of doctor's appointments, and I've got no concerns about this placement, and it's my recommendation that continue.
I say, Stacy, could you please call me in the sense of Emma's gastric problem? She was premature and she was on the Similac and the commercials that they're showing on TV. That's her. That's her problem.
Okay, then I'm going to continue the department as temporary managing conservator based on a finding of ongoing and continuing danger to return the children home. We don't know where father is, so obviously we could possibly even return the children to him. But based on Ms. Melton's most recent drug screen and struggles, I find it would be a danger to send the children home at this time. I will see everybody back for our final November 30th of 2023, and that's on a 9:00 docket. We'll see how things are going at that time. I will just call attention again to the new standing order that this court issued yesterday. If you haven't seen it, you need to check your emails. If for some reason you didn't get it, contact Ms. Katie and she will email it. But we are requiring mediation. So I know y'all don't have a lot of time between now and November 30th, but I would like to see y'all try to mediate even before that date.
Your Honor, if it's all right, would you mind ordering a hair follicle and drug and UA for Ms. Melton today?
Nope, no problem. I will order her to go do those today before 4:00. Ms. Melton, you know, if they're going to be positive, they're going to be positive. But what we're interested in now is the trend, the levels. So just, you know, don't be afraid to go do them. Just go do them. And so we can monitor your progress.
Sylvia, is your phone back working or are you still on the 57 number? Jeff, if you don't mind, can you send it to me in the chat just to make sure I have the correct one?
Sure.
Sorry, Your Honor.
No problem. All right, then. Best of luck to everybody. I'll see you back in November and we'll figure out where we go from there. Go ahead and take announcements.
Thank you, Your Honor.
Daniel Traff with the Texas Department of Family and Protective Services. Marissa Herrera is my permanency specialist, and we're present ready on.
Okay, Mr. Eldridge is not present, but his client appears to be present. We're having difficulties getting them connected to audio, but we're working on it. And Mr. Hammonds is present on behalf of Ruben Pena, the father. He is also present. Again, Mr. Hammonds, I think, is working with them trying to get the audio connected.
Stacy Zabala on behalf of the children.
Yeah, Judge, he said he's on a Samsung device. He just doesn't see any microphone icon or anything like that. But we can go ahead and proceed, Judge. I'll let him know. I'll let him know what happened.
Okay. All right, then. What do we have new from the department?
Both parents did a UA on August 11th, and they were both negative. Ruben has provided a pay stub from his current employer as well, but the parents both have still not signed the OSAR release to get those services going.
Where do they need to go to do that, or just call you and meet with you to do that?
I sent it through DocuSign a couple times, and then I can print out a copy and have them sign it in person, but I've had trouble getting them in person. We did an unannounced in July, and the state of the home was a concern. There was a lot of filth, clutter, dirty laundry, trash all throughout the home. So I told them all my visits would need to be unsupervised or unannounced, and I haven't been able to see them since. I know they had COVID for a couple weeks recently, but in August I was unable to see them.
Okay, and Mr. Hill has just logged back in. He's covering for Mr. Eldridge.
Yes, ma'am. I apologize.
Yeah, no problem. Okay, Mr. Hill, we've not been able to connect the parents to audio. We've tried, and Mr. Hammonds just indicated to them he would call them and tell them sort of what was discussed today.
Okay, and then I apologize. I'm not really sure where we are in the process, but if it's, I do have an update for you if it's my turn, or just whenever it is my turn.
Yep, sure. Here, just a minute, it will be.
Okay.
But parents, Ms. Herrera, parents have worked some services.
Yes, they started with a lot of momentum at the beginning. They did the parenting class, they've done the psychosocial, they've done the counseling. We just have not been able to address the drug use, but they have been maintaining sobriety. But I think the biggest concern is them being able to meet the children's needs, because Sophie has a lot of medical needs with her OI diagnosis. And then Samuel also has some ECI needs due to neglect with his speech.
Okay. Have we tried to keep parents in the loop on any of the doctor's appointments?
The children have just been set up with OT, PT, and they will also get speech. The caregivers have recently provided me a calendar that I was going to provide to the parents and try to collaborate with them to set up maybe some kind of like tripod and have the parents participate virtually, because Miss Armijo does not have a job and she'll probably be the main caretaker during the day if the children were to return home. Another concern is they have transportation, but not a driver's license, and Miss Armijo cannot drive. So those appointments that are in Cooks in the Dallas area, we're not really sure if we're not able to provide transportation to them, how they'll get there. And we can provide transportation during the life of the case, but when we're out of the case, it would be a concern how they get her to those appointments.
Does father have a driver's license?
No, ma'am.
So neither one has one.
Yes, ma'am.
Any reason? I mean, have they been revoked? Did they just never get them? I mean,
He says he has something in Virginia holding him back from getting his license here in Texas.
what about mom?
Mom is on disability and she is not able to drive.
Okay. That needs to be discussed with them, how they're going to handle transportation.
I've got that, Judge. I've talked to Ruben about getting the driver's license. I'll have that discussion with him again.
Okay. Yeah, that's going to be a big factor moving forward. So, okay, Mr. Hill.
Judge, the information I've received is that I guess a little different than what's been stated. That the parents were doing well, that Ms. Armijo was doing well, completed everything except 6 therapy sessions, passed all drug screens, and they were wanting to know when reunification could take place. So that's the limited amount I know, but that sounds like it's somewhat different than what was just described.
Ms. Herrera, what do you have documented completion?
They've completed parenting classes, the psychosocial, and they are in the middle of doing counseling sessions.
Individual counseling?
Yes, ma'am.
All right. Have they been asked to do RBT?
No, ma'am.
Okay. Any domestic violence, BIF,
No.
anything like that?
No, ma'am.
So transportation is a huge issue. Maintaining a clean and appropriate household is an issue.
Yes.
And then completion of counseling. And then the OSAR.
Yes.
That's the other big one.
Yes.
But they have been drug tested for us.
Yes, they've been negative since I believe April or May. The hair follicle, Miss Armijo, her last one was negative, and Mr. Pina's was positive, but it had gone down significantly.
Okay, so we're at least making progress there.
Yes.
Okay. We just really want the OSAR to see if there's any recommended services from that we need to get going on, correct?
Yes, ma'am.
Okay. So, Mr. Hill, Mr. Hammonds, it seems like that getting that OSAR evaluation done is pretty important. And then those other issues.
Judge, I can assure you when we complete this hearing, I will call Mr. Pina and I will detail every one of these concerns, and I will tell him to contact the caseworker to get that release signed for the OSAR situation.
Okay.
And they need to clean their house. We discussed that.
Okay.
And
All right, Ms. Zavala.
Your Honor, the kids are placed together in a kinship home. Sophie has lots and lots of medical. I mean, it looks like placement is very much on top of it in terms of scheduling, but there's appointments with neurosurgeons, endocrinologists, they're doing genetic testing. Looks like they're going to be placing a port, and Sophie may require, if I understood it correctly, like a lifetime port for medication. She's going to be taking meds to strengthen her bones. She needs a helmet, but is still too fragile, if I understand that correctly, for that to start yet. So there is a lot going on medically, and parents are really going to need to be in the loop on all of that. I checked in on Samuel in terms of there's a notation of his lead levels being high, and he's being retested in November. So we should know more then. They've worked with a dietitian to kind of work on some things that might help flush. The parents are having Zoom visits, and it sounds like maybe once a month in person. I can understand what's being reported to me is that mom is hesitant to hold Sophie, and I can understand that based on Sophie's fragile condition. But if mom is going to be primary caretaker, we've got to make sure that everybody's up to date on how to do that, as well as holding and taking care of her. So those are my main concerns, is making sure parents are looped in on all the medical and can show that they're able to protect two nonverbal fragile kids.
And Judge, Miss Smith put a thing in the chat as far as transportation, just if you didn't see that yet. As far as if reunification happens, possible help with transportation.
Okay, thank you, Ms. Smith. Appreciate that. Yeah, everybody take a look at that. And then Mr. Hill and Mr. Hammonds, y'all can relay that to parents. But, you know, obviously with two children, and one in particular with probably going to be lifetime, at least clear through their adolescence when parents are responsible. But, you know, medical needs, I mean, transportation is just going to be critically important for the family.
Right.
Okay, then, I will continue the department as temporary managing conservator, and I'll continue placement of the children, and find that it would be a continuing and ongoing danger to the children for them to be returned home today. We're certainly short of completion of services, and parents really need to be looped in more on the medical of the children. So we'll just keep after everything, and we'll be back for another review hearing on January 16th of 2024. We're here today on a 9 o'clock final in each case. I understand we do have motion for an extension and to retain the cases on the docket. We are conducting this through the Zoom program under a finding of a good cause and a consent and agreement of the parties. We are live streaming, and Ms. Taylor is making our record. I'm going to ask everybody to try and please be mindful this morning. Ms. Ratliff is on a short break from another court proceeding. The judge was good enough to let her go so we can address this. So we want to try to be as efficient as we possibly can be today so she can get back where she needs to be with, I think, Judge Tesh. Okay, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready on.
Judge Teresa Ratliff for the mother, Christine Messler. We're present. I'm ready with those pretrial motions.
Joel Jackson on behalf of the father, Timothy Sherrill, present, ready, Your Honor.
Ryan Turman on behalf of respondent father Tommy Messmer. We are also both present and ready.
Stacy Zavala on behalf of the kids. I would agree to and join in that request for an extension.
All right, my understanding is that all parties have agreed that they wish to have the extension in the case and to retain the case on the court's docket. Is that correct, including the department?
Yes, ma'am.
Yes, ma'am.
That's correct on our end, Judge.
Okay. In spite of that, I need to know what the extraordinary circumstances are upon which to grant that.
And Judge, I can provide the court with that information. Make sure I'm not muted.
All right. And do you need to call a witness, or you want to just?
I can summarize it.
Just, okay.
At when I filed the motion, my client was released from a 30-day rehab, 30-day treatment facility on September 6th. During that time, she was able to participate in therapy, family therapy with the kiddos, and that's ongoing. So that there were 2 or 3 visits while she was in there. I believe the department or St. Francis is working with us to make us some time because placement was consistently late to the visits. And also there was one last week they couldn't do because one of the children had COVID. So we're working on those issues. She has an appointment tomorrow with TPC to enroll in her outpatient program. Judge, couples therapy was delayed. It could have been done while she was in treatment. She tried to get that information from the department beforehand or from St. Francis. They were unwilling to set up couples therapy until she had been out of that program. So that's delayed it significantly. But they are trying to work that out at the present time. The problem is that Mr. Messmer's, Mr. Sherrill's client or Mr. Sherrill's work schedule, there's not that availability. They only want to give the mornings and he gets off at like 3 a.m. And so they're currently trying to work that out, but we'd like to get this fast tracked and moving along. I don't anticipate needing the entire extension period. I'm only asking for a reset of a couple of months. Sorry about the background.
Okay. All right. Anybody have anything else to add as far as extraordinary circumstances?
Yes, Your Honor. Although she's here and could speak for herself if needed, I anticipate that Ms. Freeman, who is Keegan's counselor, would state at this time that Keegan is improving over some of the issues that we've addressed previously, and that hopefully those issues can continue to be worked on in family therapy with that family therapist, with the 2 therapists coordinating needs and information, and that the hope is that those sleeping issues, the technology issues can be addressed through that family therapy, and we can see increased improvement for him. I do believe that Ms. Freeman would state at this point it wouldn't be in either I think she's only working with Keegan, but in Keegan's best interest for contact with parents to stop, that would be detrimental to Keegan at this time. So we're really hoping that given some additional time, we can really focus on those issues and work towards reunification.
Mr. Jackson?
So, Your Honor, I've had this conversation with Mr. Trout, and we were wanting to schedule or try to get a reunification schedule in place and try to start working this. The clock's ticking. The parents of, I think, Mr. Sherrill, he has 6 classes left on his parenting class. He's done everything else. And then the couples counseling, that's just got started. And so that's all they lack. And so we're trying to pick up some time, and all their visits take place in Lubbock. And so, and their therapy, their therapeutic visits are in Lubbock. And so these, the placement showing up late, for whenever they're supposed to have the kids. And I would like to visit with the other attorneys to see if we couldn't just start some visits on the weekend. Mr. Sherrill doesn't work on the weekend. And we could get something started there. It doesn't interfere with his work. And his work is a problem because of the scheduling right now. His hours I have from 11 p.m. to 7:30 a.m. And so it's just a problem for him having to miss this much work. And he is not going to miss his visits, but I would like the court to maybe consider a Saturday visitation, perhaps even an unsupervised visitation for that period of time.
What can we do to try to get some time on the weekend? What can St. Francis try to set up?
The concern right now, Your Honor, is that Keegan is not ready for unsupervised visits with his parents.
I'm not talking about unsupervised. I'm saying what would be supervised. I understand it wouldn't be necessarily therapeutic, but just some supervised contact.
I can reach out and see if anyone's available on a weekend. I know in Lubbock we have a contracted visitation service, but I don't know if they do the weekends, but we can certainly try to see if we can find something.
Okay.
But it would more than likely be in Lubbock. We don't have, I think, availability here in Amarillo with a contracted service.
All right.
Mr. Sherrill
What
shared
about,
with me.
what about, Mr. Jackson, what about even like a Friday afternoon? If he gets off of work at 7:30 in the morning, maybe he could catch a few hours of sleep. What about a Friday afternoon even?
That's my,
That's
my long day.
He'll be getting back late to go to London.
Yeah, because I have to go to work. I go to work.
So will it work or will it not?
No.
No, ma'am, that won't work.
Is there a day of the week that would work?
That's why we asked for the weekend.
That's why we asked for.
Yeah, no, ma'am, that's why they were requesting the weekends. He's already doing the Wednesday, but he's having to take off work from there and
And they get out of school so late.
then, yeah, they get out of school, I think at 4:30.
Okay. So I'd like St. Francis to explore if there is some possibility to get some time supervised on the weekend. Rules would be the same as when you're in therapeutic visits.
And Judge, to address the couple counseling issues, I think I don't know if there's miscommunication or exactly how that went, but I know that I believe parents had the name of the counselor, but I think the counselor is actually the one who asked for them not to call to set that up while mom was in therapy in her inpatient. So that was the situation on that. But I talked to Ms. Bird yesterday. There may be, I don't know, scheduling with dad as far as getting with his work schedule and getting therapy couples counseling set up, but she's gonna get them another list of, I believe, different counselors, maybe some different scheduling, and let them decide which ones work best for them as far as getting that set up. So that should be getting to them. So that is trying to get corrected so that they can get that started as soon as possible.
Okay.
And Judge, while we're on the subject of Mr. Sherrill's work schedule, I just wanted to let the court know and the other attorneys know that as long as he's working his services that he has remaining and all, and making his visits and doing the therapeutic visitation, I've told him that he doesn't have to show up to court and take off more work during this time. And I'm just trying to free him up so that he can maintain his employment. And I didn't think the court would help with that.
As you well know, Mr. Jackson, I never penalize a parent for missing a court hearing because they've got to be at work.
Yes, ma'am.
So that's not a problem, Mr. Sherrill.
Explain to them to just give me.
You might even be able to just, we do most of these still by Zoom, Mr. Sherrill, so you might even be able to just take a short break at work and log in. I have a lot of parents who do that. It's one of the great benefits of electronic proceedings. So, if you get a break, if you get a 10-minute break from work, maybe then you can make that your 10-minute break, hop on with us, and that's fine. So
okay.
Yes,
lots and lots of parents do that. Okay. Mr. Sherman?
First, Judge, I guess, are you asking me if I have anything to contribute as far as the extraordinary circumstances?
Yes, sir.
Okay. I would acknowledge, Judge, Mr. Messmer's primary difficulty that we've had is establishing stable housing. He has found employment in the last several months, but he's still struggling with stable housing. My understanding is that most recently he was residing with the Sherrills, but was recently evicted by the landlord due to just not being on the lease. So he's currently residing in his automobile. But when I spoke with him yesterday, he tells me that I guess he's got a line on a home and trying to get that finalized and sorted out. So we anticipate that he should have a roof over his head here in the short term. And as again, as far as extraordinary circumstances go, I think this eviction was somewhat unforeseen. Maybe with some more legal sophistication, it would have been more foreseeable. But I don't think they were expecting for him to find himself homeless. So we're currently working on that. He's done a fantastic job of getting his services done of late. Stable housing is the main thing we're working on, and we're hoping to get that done soon.
Okay.
And I would like to address another issue, but I'll do that whenever the court.
No, that's fine. Go ahead.
Just to piggyback on the Cheryl's request on visitation, Judge Mr. Messmer, I would remind everybody, was the non-offending parent at the inception of this case. He's worked his services well. I think there's still a little bit outstanding, but he's been pretty on top of that. Just yesterday, I believe I received a bunch of visitation notes. There was a lot, so admittedly, I only had a chance to give those a cursory review, but it appeared to me that he's incredibly appropriate. It was just very sweet interactions that I had the pleasure of reading between him and the child. Mr. Messmer has had negative drug screens most recently this month. Prior to that, I think we had some pretty low level THC positive tests in the earlier months this year, but he was clean in September from everything. And while he doesn't have a home, he does have a vehicle. So I would ask that maybe he be given some unsupervised visitation with the child.
All right, what's St. Francis's response to that?
Yes, that's correct. As far as the services, I think the biggest issue was, just throughout the case, he has tested positive for marijuana, but, like Mr. Sherman stated, for September, he was negative for all substances. Services he has worked. Up until today, I didn't know he had a vehicle. I know that there were some issues with transportation, and we've provided that up until mid-August. And so we've done virtual. But I might possibly have to check with my supervisor as far as going to unsupervised. Just any decisions, I try to just staff with my supervisor. So she might can answer it a little better.
Fortunately, your supervisor is here.
May I interject? I'm sorry to cut you off, but I just want full disclosure. My memory from reading the report was that he had transportation. That's where he was living. But I don't want to misrepresent things. If you're saying you didn't know that, maybe I'm the one that's wrong. So since we have Mr. Messmer here, can we confirm that he does have a vehicle?
What I read too.
Okay. Mr. Messmer, you do have a vehicle, correct?
No, I got a blown head gasket in it, so I can't make the drive to Lubbock in it.
That's what I was gonna say, man. I think he has a vehicle. I don't think it's reliable transportation.
Okay.
Yes, exactly.
But it serves locally. Tommy,
Kind of, like I said, it's got a blown head gasket, so it'll overheat.
Okay. But you can drive it around town?
Very seldom.
Okay. Well, then maybe I got it in front of
It's kind of limited. Yeah.
Okay.
I'm trying to work on that too, so.
Okay.
And
if he gets it up and running, and that, then you all can, everybody put heads together and talk about it. I'm not opposed.
St. Francis would be willing to give him more phone contact at this point until he does get a running vehicle. Because I know he won't be able to make it down to Lubbock, but we can certainly authorize more phone contact at this time.
Which would be fine. I mean, Cameron's what, 14?
Yes.
He'll be 15 in December, and I've got no concerns about Tommy visiting with Cameron if he can get there. I mean, I don't have any safety concerns about that interaction.
Okay. So until he's got a working vehicle, we can just ramp up the amount of phone access that they have. That's fine. Okay. And Ms. Vala, anything further?
No, Your Honor. I mean, Keegan still has issues. I mean, that's part of this extension, is to work through that with parents. But he is showing progress. I was able to meet with both boys in person on Saturday. They're doing well, and I think this extra time will give time to work on that family therapy to get Keegan in a better place, because there are issues that still need to be addressed, but I feel like we can get there through the family therapy.
All right.
Judge, that'd
yes.
be one thing we'd ask. I know they're doing the therapeutic visits. And I talked to Mr. Gowan yesterday. I think he's got 2 more weeks scheduled of that. And then maybe move into to help with the possible ramping up to reunification stuff, once parents work their services, finish up their services, but, going more into a family therapy situation, but due to that being part of the reunification process anyway, and start working toward that also, is what we're gonna look at doing.
All right, well, I think we've covered the grounds for the extension. I think we've also basically done a full review today. So it's time then. I will find that there are extraordinary circumstances which support granting an extension in the case, primarily mother's drug treatment, and then the fact that we are continuing to work with Keegan. So we will set a new dismissal date in the case. Has anybody figured out that date yet?
The new dismissal date would be March 22nd of 2024.
Okay, and I will also increase Mr. Messmer's telephone contact with Cameron, continue with the therapeutic visits with Mother and Mr. Sherrill, and anticipate that will roll into family therapy. I do want St. Francis to look at some weekend time if it's feasible to do. And then Miss Katie, I don't have any other dates here. Do you have anything in mind?
Well, I don't know how far out you want to go for the final.
Yeah. I would like to go ahead and I know nobody wants to go another 6 months, but folks, I just see that this is going to take longer than the next 90 days. I don't see it wrapping up that fast. So let's just set another review hearing and then a final that's closer to the dismissal date. And certainly, if everybody thinks we're ready to wrap up, then one phone call, we'll get a date and we'll set it. Resume our final hearing, which began on September 5th of 2023. At that time, I had indicated to the parties that I would like for them to try to work out some kind of visitation child support arrangement. And if they were unable to do so, then we would regroup today and I will render some orders. However, I also indicated that when we recessed, mother or father had not put on any of their cases, and that certainly they would be permitted to do so. So I think the department had rested. In department called mother and father as witnesses, but nevertheless, neither Ms. Naranjo or Mr. Hill have had any opportunity to put on their case. So Ms. Naranjo, any witnesses to call?
Just Ms. Hanson briefly, Your Honor.
All right, Ms. Hanson, you were previously sworn in this matter. So you are still under oath. Just since we're here on a new day, I'll show that everybody is in attendance. Everybody is present today.
Ms. Hanson, did you and I discuss a proposed visitation schedule for Mr. Chambers with Remington?
Yes, ma'am.
And can everybody hear her okay? I barely heard her.
Oh, hold on.
I can barely hear.
Okay.
Yes, we did.
And it was a step-up visitation plan, basically with 2-3 steps before it went to standard visitation, correct?
Yes, ma'am.
And I have provided and e-filed a copy of that visitation schedule with the court. Is that correct?
Yes, ma'am.
And are you asking for that proposed visitation schedule to be considered by the court today?
Yes, ma'am.
Now, are you also asking that all the visitation for the first 3 steps occur in your place of in your county of residence?
Yes, ma'am.
And after Mr. Chambers goes to standard visitation, are you asking that he pick up and drop off Remington at your residence?
Yes, but I would like to point out to the court that I'm just not right now able to travel, but I am willing to, modify how we split the burden of travel.
So for right now, it's not financially feasible for you to split the travel. Is that correct?
Not at the moment, no.
But you would be willing to work with Mr. Chambers in the future to address travel concerns and issues if need be?
Yes, ma'am.
Now, are you also asking that child support be set at $200 a month?
Yes, ma'am.
And did you hear the judge previously mention about potentially setting child support at $260 a month?
Yes, I did.
And are you asking for the reduction to help Mr. Chambers with travel expenses?
Yes, I think that's fair.
And do you believe that the proposed visitation schedule that you've provided to the court is in the best interest of the child?
Yes, I do.
And do you believe that step-up visitation would be best for Remington to help him adjust?
Yes.
I'll pass the witness.
Thank you, ma'am. So Ms. Hanson, in the end result, you're okay with just standard visitation, is that right?
Yes. I just am not able to travel or commit to a traveling schedule, if that makes sense at the moment.
So in one of the, or I guess the proposal that we had sent to your attorney, which I'm sure that she spoke to you about, we had listed in there that you would travel one way, either to drop off or to pick up Remington for his times of visitation with his father. Were you aware of that proposal that we made?
Yes, and from what I understood from my attorney, we both agreed that if it were on paper and I couldn't comply or I couldn't, afford the traveling expenses at the time, I just didn't want to be held in contempt of court, which that's why I feel like right now it's like a good starting point with what my lawyer proposed, but in time I would be totally willing to modify it, or, I'm really just willing to work with Richard to eventually get to that point where I wouldn't mind traveling to drop Remy off. And, I'm not trying to ask Richard to have to take all that time off from work as well, because I know he has to make a living and especially paying me child support. So it's just right now I'm not able to commit to a parenting plan that would kind of, tell me that I have to travel when I just don't have the means to travel.
Okay. Now, currently, my understanding is that the video visits that Richard is having with Remington, it's court ordered. It has to be twice a week, but my understanding is currently it's quite a bit more frequently than that, just by voluntary agreement between you and Richard. Is that correct?
Yes, with my son being autistic, I don't like the fact that he has to, he can't focus for a long period of time. And we're working on that in school with him doing so. But I think it would be beneficial for Remington if we could, I will totally abide by the 2-hour visits that are demanded weekly, but I would like to break them up into smaller visits to accommodate for my son and his focus span.
Well, and I don't think I think Richard fully understands that, that, and I see him shaking his head, yes, that the child's attention span can't always be held for that long. My point being was it's court order for 2 times a week, but it has been almost daily.
Yes.
At bedtime, is that right?
Yes, and it's about 20 to 30 minutes.
Okay. And
so I guess if you broke that up with his work schedule, it is about 2 hours a week, but broken up into smaller portions of time.
Okay. And are you willing to, even if it's not on paper, I mean, it's only a 30-day time period for step 1, but are you willing to continue to let Mr. Chambers have, basically the almost nightly bedtime kind of visit with Remington?
Yes, because I realize it's hard to, juggle 3 jobs, especially having to go from one job to another. And I'm not having to do that. I have a set schedule. So the evening times seem to be the most beneficial for both parties.
Okay. Now, with respect to steps 2 and 3, they're each 90-day steps, and the visitation conditions that you've got in them. Are you requesting that, so like on step 2, once a month on Friday and Saturday from 2 to 4 p.m. So that basically would be 3 weekends worth of visits, if I'm understanding this correctly. Would that be accurate?
I believe so,
Okay.
but I would like to say that, I know that, like I said, my lawyer and I discussed those as starting points, but I would hope that the judge would agree that if he's going to be paying all that much to travel, that they wouldn't be so time constrained, if that makes sense.
Well, so any final order that the court renders, at least if she adopts standard language, would have a provision in there that this is the court order, this is the minimum, this is what you have to go by. but it can be modified by agreement of the parties. So in other words, if the two of you feel that more is better, you can't give him less. He's entitled to what's on the paper in the order. But if the two of you agree, he could get more.
Right.
So is that what you're saying, is that you would potentially be willing to give him more time than just those, if he came all the way from Oregon, more than just the 2 4-hour visits on a weekend?
Yes, I would. I think that's only fair that he's paying for all the travel expenses.
Now, so in conjunction with that, are you in step 2, for example, it consists of 3 visits. Are you wanting to stay on step 2 until 3 visits are accomplished, or are you just wanting to, so let's say he makes it 1 month, can't come the next month, but does come the 3rd month. Is that in your mind? Is it the 90 days and that satisfies step 2? Is that your understanding of that?
I believe so, because I think that we can't, I don't think we can really control how finances go. And if he's working 3 jobs and has to work around 3 jobs and his schedule, I think that would satisfy me, yes.
Okay, so basically step 2 is 90 days and step 3 is 90 days as well. Even if a visit or 2 visits or whatever, even if some visits are missed, the steps are just 90-day steps is what you're asking for.
Yes, sir.
And then the very last thing on the proposed step-up visitation plan, well, I guess it's not the last, but it's entitled electronic communication. So you're still willing, in addition to standard visitation, you're willing to continue with the electronic visitation, the Zoom or however you do it.
Oh, absolutely. I think with the distance, it's probably the only way that Remy's going to be able to adjust himself to, seeing his dad.
Okay. All right. Thank you, ma'am. I will pass the witness.
All right, Mr. Hill.
Thank you, Judge. I'd like to call Richard Chambers, please. And you heard the testimony with regard to Alyssa's proposed step-up visitation schedule. Is that right?
Yes, I did.
And we discussed that previous to this hearing as well, correct?
We did, correct.
And we made a proposal to Alyssa, which they declined. Is that right?
That is correct.
And I guess basically, so you're asking for standard visitation with elections for Remington. End result, that's what you're asking for, correct?
Yeah, once I read your email, I didn't quite understand what with elections means. So
okay, just some added extra visitation time. If you're living in the same area, you get some extra visitation time that you wouldn't otherwise have.
Okay, well, that makes sense, but obviously right now I'm not in the same area. So yeah, the standard visitations, yes.
Okay, but you were since you were objecting to the step-up visitation plan, you believe that to be unnecessary. Is that
yeah, I mean, but with the distance, it just it seems like it's going to make sense and work out that way anyways. So
okay, so are you no longer opposed to these 3 step-up visitation timeframes?
I don't think they're necessary, honestly, but I just want to get through this and move forward. I can abide by them by all means. I just don't see the relevance, I guess.
Okay, well, let's take step number 1, for instance. You've already been on step number 1 for several months, correct? With the video visitation?
Almost a year, yeah.
So really step 1 is basically the same thing you've been doing for months.
Correct.
And then you understand step 2 and step 3. I talked to you about those and you understand those as well, right?
I do. Let's see here.
Okay, well, step 2 is in-person visitation on Friday and Saturday from 12 p.m. to 4 from 12 to 4 on a Friday and Saturday once a month for 3 months for 90 days.
Okay, yeah, and I mean, like I said, I agree with what Ali was saying as far as if I'm going to be spending the time away from work and the money to go out there, I would feel that it should be a little bit more than what was proposed in step 2. And her and I have discussed this and she agrees. So yeah, I guess, there's definite parts that I just, like I said, I don't see relevant to the process.
Okay, so you understand her proposal. You're willing to abide by it if you have to, but you think the steps 1, 2, and 3 are unnecessary. Would that be bottom line?
That is bottom line, correct?
And are you asking the courts order Alyssa to provide travel expenses for Remy one way of any journey that he would take when he comes to visit you? That's something that you had asked for. Is that something you're asking the court for?
Yeah. At the same time, the financing part and with Alyssa's position, as far as her finances, I can understand how it could be difficult, and I don't want to put her on the spot or make her think that she'll ever, have any reason to feel in contempt. The way I explained it to her was that, if this is what was agreed on, then I would never allow her to be in a position to be in contempt. If she can't afford to come one way or the other, I could always chip in and help out. But that is what I asked for. And the main part, other than finances, is just me asking for this extended time off from any of my employment, and just that we could share that load.
Okay, and just to make clear, the only load that you're talking about would be Alyssa to travel with Remington one way. So in other words, if she was bringing Remington to visit you, she would pay for her ticket to get Remington there and her ticket to get herself back.
Correct.
You would always pay for Remington's travel ticket, and then obviously the return trip or your portion of the travel, you would obviously pay for that as well. So in other words, if Alyssa was bringing him to visit you and then you were to take him back home, you would pay your travel and you would pay Remington's travel both ways, correct?
That is correct. Yes. I had no problem paying for my son's travel. Obviously, he's not old enough to travel by himself yet. And I'm more than willing to go one way and, back the other. And when it comes down to it, if I have to, hopefully I can come up with a way to make it work where I have to do all of it. But I wanted to ask that we share that once we're both able to, not just myself, but Alyssa as well. I don't want to financially burden her in any way any more than I want to financially burden myself.
Okay, and just to clarify, I think I've been using relatively poor language as well. You specifically mentioned one way, and I might have mentioned one way as well. To clear that up,
round trip.
The better way to state that would be one leg of the trip, either the delivery or the pickup.
Correct.
Not one way, but
correct. One leg.
All right, and you are in agreement to pay the $200 per month child support that she's asking for?
I am.
All right, is there anything else with respect to the visitation schedule that the judge is going to have to come up with that you would like to request or want her to know that I failed to ask?
No, that's it's pretty cut and dry and clear. I just wanted to correct real quick. Allie's talking about me juggling 3 jobs. Well, as of yesterday, I've been laid off of one of those jobs because of it's a production job and we're just slow. Bottom person on the list. So I am still working 2 that I just recently got hired at. I think that 200's fair as far as in respect to that. Other than that, I got nothing else.
All right, thank you. I'll pass the witness.
All right, Mr. Trout.
I have no questions, John.
Ms. Naranjo.
Thank you, Your Honor. Mr. Chambers, when was the last time you saw Remington in person?
February of this year.
And before February of this year, what was the last time before that you'd seen Remington in person?
July 2nd of 2020.
So it's pretty fair to say that your in-person contact with Remy is pretty sparse at this point.
It has been very limited.
Mr. Chambers, as far as the visitation plan and everything, you understand that regardless of what's in writing in court, that you and Ms. Hanson will always have the opportunity to agree to something different, correct?
That's, since it's being stated now, yes, that's very clear.
And then in the event that you guys do not have an agreement, then you understand that you'll fall back on what's in writing in the court order, correct?
That's fair.
I'll pass
Correct.
the
All right, Mr. Hill, anything further?
No, ma'am, no, nothing further. I'll rest.
Okay. All right, Ms. Zavala, anything to present today?
First, I'd like to commend the parents for working together. It feels like they're going to be able to make this work. And I think that's in Remy's best interest. In terms of the visitation schedule that's been suggested, it does seem like step one has already been made, that has been what's going on. I could see some benefit in Mr. Chambers having to come here at first. Remy is autistic. He's, there are a lot of things for him to get used to. It makes sense to me to have the first longer visits here in case there are any kind of meltdowns. And it seems to me like the parents are going to be able to work on those actual timeframes. But I do see the benefit to at least a few visits here in Remy's home environment before the extended travel. But it does look like parents are going to be able to work out something that works for him and in his best interest.
Thank Mr. Chambers and also Ms. Hanson for their cooperation and what appears to me to be parents getting off on a really good foot as far as co-parenting and cooperating with one another. It is important that you all appreciate and understand each other's limitations and do your best to work around that. Most importantly, it's critical that you understand your child's limitations and respond accordingly. Remington's situation is likely going to dictate that you all are going to have to be flexible. And, sometimes that flexibility doesn't give much advance notice of things. I have seen situations, I'll just tell you, Mr. Chambers, I've seen situations in the past where, particularly with a child with autism, parent travels a great distance to pick up a child, and then there's a full-blown, disaster. Child just, won't go, just can't be consoled, can't be, and it can be the absolute other way around, Ms. Hanson. If you go, and I'll explain my ruling, but you may be picking him up from dad and the same thing happens. So, you all at being at such a great distance from one another, it's going to make this way more difficult. I would encourage you all to explore while you're both somewhat in transition and kind of reestablishing yourselves. I would encourage you all to explore the possibility of getting, together closer geographically. I think it would make your lives much easier. I think it would make your child's life much easier. But, I don't have any authority to make y'all do that, but I hope that you will keep that dialogue open, because it seems to me you both are still in sort of that kind of in a transitional phase, and the roots aren't so deep anywhere right now that maybe a compromise couldn't be reached. But, that's just a suggestion. So I have, I had reviewed what Ms. Naranjo had filed and proposed, and I also then have listened carefully to each of you and your concerns. I'm modifying what Ms. Naranjo had at least filed and presented to the court. So I'm going to go through this fairly slowly, but I think if you're looking at her proposed step up, you may be able to kind of go along, but I'm happy to email my ruling out. My ruling uses some shorthand phrases, but you could put it in, I think you all could redo it into the context of more like a possession order. So essentially what I'm going to do is I'm going to order that, of course, for all steps. And once even standard possession starts, Mr. Chambers will continue the virtual visitation, at least twice a week for 2 hours. That's a minimum. If y'all can work it out, great. If it can be more than that, and split up however you best determine to split it up. Doesn't sound like that's going to be a problem, but that will just continue, indefinitely. All right, we're going to call step 1, in-person visits. I'm going to order that Mr. Chambers will have visits once a month on a Saturday from 8 a.m. to 6 p.m. And then on that same weekend, on Sunday, 8 a.m. until noon, or until 6 p.m. if his travel plans will accommodate that. In other words, if he's got a 4 o'clock flight, maybe he can have the child till 2 p.m. If you can get a flight after 6 p.m., that's fine. But obviously, when you're making that long a trip, I want to try to maximize the time that you would have with the child. So Saturday, 8 a.m. to 6 p.m. and then Sunday, 8 a.m. could be as late as 6 p.m. if your travel accommodates that. 14 days notice, I think, is reasonable to give, and that's pretty standard anyway, of your intent to visit. Step 1 visits will be in the county where the child resides, and that'll be for 60 days or 2 of those visits. And the reason I'm qualifying that is because, I can just foresee it may not be feasible for you to make those visits 2 consecutive months, with the distance and your financial constraints. So I'm giving you a little flexibility there. So, it'll be, if you do make those consecutive visits, then it'll be for 60 days. If you don't, then it'll be for 2 of those kinds of visits. All right, then step 2 will be in-person visitation, and we'll start into overnights. So after step 1 is completed, then you would have visits with the child once a month from Friday at 6 p.m. and ending at Sunday. Same thing, noon or 6 p.m., whatever your travel plans accommodate. Again, 14 days notice. Visits will be where the child resides. Same thing, 60 days and or 2 of those kinds of visits. All right, thereafter, I'm going to implement a standard possession order, and that'll be drafted, of course, for parents who reside within or beyond 100 miles of one another. And I'm going to put in any of the elections that are permitted under the code. A lot of those can't be exercised unless you live really close together, but I'll put it in there because I don't know what the future will bring. All right, at that point in time, Mr. Chambers will pick the child up at the beginning of his visitation from Ms. Hanson. And then Ms. Hanson will pick the child up from Mr. Chambers at the end of that visitation. Each parent can elect their mode of transportation. If you want to fly, fly. If you want to drive, you can drive. So whatever you want to do. I would like that standard language in the order regarding air travel with the child. I think that's obviously needs to be included under our current geographic parameters. And obviously those visits would not be restricted to the child's county of residence at that point. All right, then beginning October 1st of 2023, I'm going to set Mr. Chambers' child support at $200 a month plus $50 a month in the medical support. But beginning February 1st of 2024, then Mr. Chambers, I'm going to increase your child support to $260 a month plus the $50 in medical. So you'll start at $200 while you're bearing this transportation, but once you all start sharing the transportation, essentially it'll go up to $260. The February date is just based on, if you work your way through this step-up visitation, and then that's about the point where you all will hit standard possession. So, but because the way orders have to be drafted, I need to give a date certain on that increase.
I may have just confused myself. I had it down that it was like it had to be 2 visits before it moved to the next step, no matter how long that took. Is that
No
right?
matter how long, no matter how long that takes. Yeah,
Okay.
it's gotta be
Okay.
two.
Okay, so it's 2 visits regardless of 60 days or 90 days or 120 days. It's 2 visits to end each step.
Yeah, and if you all want to just rephrase it and say that'll be for 2 visits, that's fine. Yeah, the only concern, and all of you guys have practiced law long enough to know that, we've seen these situations where somebody exercises 1 visit and then the next year they exercise the second one. It isn't, and Mr. Chambers, I am not suggesting you're going to do that. I'm just telling you, then it becomes problematic because, a whole year's gone by, the child hasn't gained any level of comfort, so, if that happens, then all I can tell y'all is get ready. Somebody's going to file a modification. So, the spirit in which this is being made is that you're going to do the visits. Hopefully you can do them consecutive months and move right along with this thing. But I can also foresee that it might be difficult, and you might have to do every other month. But my anticipation is certainly not that it would be one next month and 1 6 months from now. But I want to leave you all some flexibility because of, like I said, just because of the parameters we're working under here. So, all I can say is if it all falls on its face, somebody's going to be back probably asking to modify, but it won't be with me. But, I hope it doesn't come to that. I really don't. So if y'all would prefer the wording to be that he will exercise 2 of those visits within a certain time frame, we can say it that way. I'm open to suggestion before it goes to the next level. Ms. Zavala, would that be preferable to you?
I think I'm fine. I mean, that'd be fine either way, but the reason I was asking for clarification on the 2 visits was I could see a situation where 60 days goes by and he wasn't able to, for some reason, get down here. And it doesn't just, after 60 days, it doesn't just automatically move to step 2, is what I wanted to clarify.
Perhaps the better, perhaps it just says it'll be for 2 visits to be exercised within some reasonable period of time, and just forget about the 60 days on each of those levels. Just say visits. He will have 2 of those visits to be exercised within a 90-day period of time. Then it moves up to step 2. And perhaps that's a better way to phrase it.
Judge, if you're going to do that, I would request maybe 120 days. That would give him the possibility to come every other month if his finances got strained.
So I just foresee this could be a problem. So no, so everybody can think out loud. That's fine with me. But I think we would let's just phrase that to say, he will exercise. We'll have 2 of these visits within 120 days before going to the next step. And that language would apply to step 1 and to step 2.
And Judge, on that note, is that going to move the February deadline for the child support to increase? Because that's going to push before we hit standardized visitation.
I understand. I really wanted to tie it to when we started standard possession, but I'm not sure that the Attorney General's office will be happy about that language at all.
Okay.
We can put it in there that way, but what that's going to require is somebody's going to have to issue a new withholding order. They're going to have to, do all that. So, then it just kind of falls out there and it doesn't happen. And, Ms. Zavala's shaking her head affirmatively, as she well knows.
Well, I didn't know, since we were pushing it 2 months on each, if we moved it, did you want me to keep it February 1st to 24 to increase, or move it to like April of 24? I mean,
I have no problem backing it up, unless, I'm just was trying to contemplate if this goes quickly, then
yes, ma'am.
Ms. Hanson's going to be doing half of the travel. And so I felt like at that point, she got to receiving 100% of what I think her child support should be.
Right. Yeah.
We can, maybe we can kind of compromise and either say March 1st or April 1st.
And that's, like I said, that's up to you and the parents. I just wanted to make sure what I was putting in this order when I did it.
Yeah. And that's the problem with having to do a date certain, but I just know that it's problematic if we don't.
Yeah. Yes, ma'am.
So, Ms. Hanson, are you good with April 1st?
What was the first date?
February 1st. I'm bumping it back a couple months. March 1st, everybody can live with March 1st?
I think I can live with March 1st.
Mr. Chambers, are you good with that?
Sounds good. Right around spring break time.
Okay. All right.
So we'll
And
increase child support. I'm sorry, we'll increase child support on March 1st of 2024.
Right.
Okay.
And if you guys sort of get through all this initial stuff, I mean, the standard possession stuff may start around March 1st, and that'd be great because it would encompass spring break visitation. And, you know, that's just financially, it's a lot more feasible for everybody because it's a longer period of time, you know, so.
Yes, ma'am.
Okay. Ms. Hanson, do you have any family in the area where Mr. Chambers resides?
I do. I have a mother and a brother.
Okay, that's what I thought. So, you know.
I don't mind visiting with them as well if that makes my traveling expenses easier.
Yeah. I mean, y'all may work it out where you and Remy make a trip up there and he pays for Remy's flight and you pay on your own flight. And then, you know, you just stay in the area. I mean, sky's the limit on what you guys can work out.
Yep, that sounds good to me.
Okay. All right, I'll email this out just so you guys got my little skeleton, but certainly feel free to change the language and make it prettier. Ms. Naranjo's was very pretty.
Thank you, Judge. I tried.
So, no, I mean, my intent is it would just kind of track the normal standard possession order language. So, okay, I appreciate it. Thank you all for all your hard work. And at this time, then parents are going to be named joint managing conservators. Ms. Hanson will have the right to establish the child's residence. Visitation, as we've discussed, child support, as we've discussed. Department will be dismissed, and all attorneys will be dismissed from the case. And congratulations to both of you. I mean, you guys are a real success story, and it's very refreshing to have parents who are willing to work together. So thank you.
Thank you, Judge.
Thank you, Your Honor.
All right. I wish you guys the very, very best of luck and Remy, and I hope everything goes great for y'all.